Hello, and welcome everyone to episode 2 of Raising the Bar. I'm Gaurav Rai, and in today's episode, I will try to unpack what does the court need to check while referring parties to arbitration in an application under Section 11 of the Arbitration Act in light of the recent judgment of the Supreme Court in ASF 𝐕𝐢𝐝𝐻 versus 𝐉𝐻𝐻𝐻𝐻𝐻𝐻. So, the 2015 amendment to the Arbitration Act inserted Section 11(6)(a), wherein the courts were given a clear legislative mandate that only the existence of an arbitration agreement is to be seen at the time of referring the parties to arbitration. This was necessary to tackle the problem of Section 11 petition pending for years on end at the High Court level. The entire purpose of a speedy dispute resolution process by way of arbitration was getting lost due to this pendency. The Hon'ble Supreme Court in Vidya Drolia reiterated this position in strong words. However, they also stated that courts at Section 11 stage could intervene and decline to refer matters to arbitration if the case was a dead wood. But in May 2025, the Supreme Court in ASF 𝐕𝐢𝐝𝐻 versus 𝐉𝐻𝐻𝐻 has clarified that this window of interference, as propounded in the Vidya Drolia judgment, has already been overruled. The Supreme Court referred to the judgment of the 7-judge bench in the reference titled Interplay Between Arbitration Agreements under Arbitration Act and Stamp Act in support of this conclusion. In ASF 𝐕𝐢𝐝𝐻 versus 𝐉𝐻𝐻𝐻, the Supreme Court has clarified that at the Section 11 stage, courts should only check whether an arbitration agreement exists. That's it. All other issues like whether the claim is maintainable, whether it's barred by limitation, or whether all necessary parties have been impleaded are not for the courts to decide at this point. Instead, such matters are to be addressed by the arbitral tribunal itself. It specifically relied on Cox and Kings to reiterate that impleadment is an issue to be decided by the tribunals. This judgment streamlines the arbitration process by limiting court intervention, ensuring that arbitral tribunals, which are designed to handle such disputes, have the primary say on all matters, including those of maintainability, as all such matters require leading of evidence, which the court at Section 11 stage is not supposed to go into. It is a move towards efficiency and minimal judicial interference, upholding the spirit of the Arbitration Act. That is all for this episode. If you have questions or want to hear more on this or other legal topics, drop me a message. For more insights, subscribe to my social media channels. Stay tuned, stay sharp, and keep raising the bar.